so Mr. Aiken, I'll give you this. You can keep this with the exhibits. That'll be passed to the jury. And let, if you don't mind, Mr. Hoffman, Mr. Brand, and Mr. Hess look at it.
We have copies, Judge. We have copies.
You do have copies? All right, then keep that with the exhibits if you don't mind. The charge is complete. It's on the jump drive. And there was that one question of the 3 exhibits that were conditionally marked. Have the defense and state been able to resolve that question?
Yes, Your Honor. The state has no objection to the admission of exhibits 43, 44, and 45 moving from conditionally accepted into the record at this point.
Very well. Then any notation, Ms. Gray, on those stickers that those are conditionally accepted will be removed, and they'll be received into evidence, and they will be furnished to the jury for their deliberation. Now, as far as I recall, those are the only evidentiary issues that we had remaining. Is that your recollection, Mr. Hess?
Yes, Your Honor. The state agrees.
And Mr. Hoffman, Mr. Brand, is that your recollection as well?
I didn't hear what you said.
You didn't?
I didn't hear. I'm sorry.
As far as I recall, that evidentiary issue regarding those 3 exhibits was the only evidentiary issue we had remaining.
I believe that's right.
Okay, very good. I'm ready to bring in the jury. Is the state ready?
Yes, sir.
Is the defense ready?
Yes, we're ready.
Let's bring the jury in. Y'all remain seated, though, until I see that they're coming in. All right, please rise. Thank you, everyone. Please be seated. Good morning, ladies and gentlemen. At this point, I will read with you the charge. And if any of you need a better vantage point, especially those folks over there in the corner, if you all want to come down and we'll put chairs here in the well for you, or if you can see the screen from where you are, that's fine. Just let me know what's most convenient for you, okay? Are you all right? Very good. Let's bring our lights down. Ladies and gentlemen of the jury, the defendant Ashley Kroese is charged in the indictment with the offenses of vehicular homicide, point rate or greater, vehicular homicide by recklessness, and reckless aggravated assault resulting in death. The defendant pleads not guilty to these charges. The indictment in this case is the formal written accusation charging the defendant with crimes. It is not evidence against the defendant and does not create any inference of guilt. The evidence in this case has been completed, and it's now my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it's your duty to carefully consider all of them. The order in which these instructions is given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, the court has ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, nor any remarks which I have made do I mean to include, to indicate any opinion as to what the facts or your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made or are made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding the case. You should consider all of the evidence in light of your own observations and experiences in life. The law presumes that the defendant is innocent of the charges against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all of the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The burden is upon the state to prove by preponderance of the evidence that the offense was committed in Williamson County. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was commenced or consummated in Williamson County, Tennessee, you must return a verdict of not guilty. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court referred to what happened and was testified to by witnesses who saw or heard what happened firsthand. If a witness testified about what they saw themselves or heard, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. For example, if a witness testified that a witness saw it raining outside, that would be direct evidence that it was raining. If a witness testified that the witness saw someone enter a room wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence from which you could conclude that it was raining. Do not assume that direct evidence is always better than circumstantial evidence. According to our law, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one or say that one is better evidence than the other. You should consider all of the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of the witnesses and the weight to be given their testimony. If there are conflicts in the testimony of different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that all witnesses testify truthfully. In forming your opinion as to the credibility of a witness, you must look to A, the proof of any of his or her general character, B, the evidence, if any, of the witness's reputation for truth and veracity, C, the evidence and respectability of the witness, the intelligence and respectability of the witness, D, his or her interest or lack of interest in the outcome of the trial, E, his or her feelings, F, his or her apparent fairness or bias, G, his or her means of knowledge, H, the reasonableness of his or her statements, I, his or her appearance and demeanor while testifying, J, his or her contradictory statements as to material facts if any are shown, and K, all of the evidence in the case that tends to corroborate or contradict him or her. The defendant has not taken the stand to testify on a witness, and you shall place no significance on this fact. The defendant is presumed innocent. The burden is on the state to prove her guilt beyond a reasonable doubt. She is not required to take the stand in her own behalf, and her election not to do so cannot be considered for any purpose against her, nor can any inference be drawn from such fact. During the trial, you've heard testimony from Dr. Feng Li, MD, who is described for us as an expert in the field of forensic toxicology. Trooper Gerald Buchanan, who is employed by the Tennessee Highway Patrol and who is described for us as an expert in crash reconstruction. Lieutenant Anderson Shelton, who is employed by the Tennessee Highway Patrol and who is described for us as an expert in crash reconstruction and crash data analysis. And Special Agents Jacaya Ogilvie and Joe Casabueno, who are employed by the Tennessee Bureau of Investigation and who are described for us as experts in the field of forensic toxicology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. In giving his or her opinion, each expert testified that he or she took into consideration certain statements made by others. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion, testimony, and cannot be relied upon as proof of the truth of the matters asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept that opinion. The same as with any other witness, it is up to you to decide whether you believe the testimony and choose to rely upon it. Part of that decision will depend upon your judgment concerning the witness's background or training and experience, and whether it's sufficient to give the expert the opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all of the other evidence in the case. A witness may be impeached by proving that he or she has made some material statement out of court which is at variance with his or her evidence on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken with you to the jury room when you deliberate, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, it's the burden of proof on the state to show that the defendant now in trial before you is the identical person who committed the alleged crimes with which he is charged. In considering the identity of a person, the jury may take into consideration all of the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant committed the crimes charged against her, and you're satisfied beyond a reasonable doubt that she's been identified as the person who committed the crimes, then it would be your duty to convict her. On the other hand, if you're not satisfied with the identity from the proof, or you have reasonable doubt as to whether she's been identified from the whole proof in the case, then you should return a verdict of not guilty. The state must have proven beyond a reasonable doubt all of the elements of the crimes charged and that they were committed before the finding and returning of the indictment in this case. Count 1, vehicular homicide, parentheses, intoxication. Any person who commits the offense of vehicular homicide, intoxication, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim by operation of an automobile. 2, that the defendant acted recklessly. And 3, that the killing was the proximate result of the defendant's intoxication. Count 1, lesser included offense, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Count 1, lesser included number 2, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. In count 1, lesser included number 3, driving under the influence. A person who commits the offense of driving under the influence of an intoxicant is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant was driving or in physical control of an automobile or motor-driven vehicle. And 2, that this act occurred on any public road or highway. And 3, that the defendant was under the influence of an intoxicant. Count 2, vehicular homicide, 0.08 or greater alcohol concentration. Any person that commits the offense of vehicular homicide, 0.08 or greater alcohol concentration, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim by operation of an automobile. 2, that the defendant acted recklessly. And 3, that the killing was the proximate result of the operator's intoxication of 800% or greater. Count 2, lesser included number 1, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. We define the defendant guilty of this offense. The state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Count 2, lesser included offense. Number 2, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Count 2, lesser included. Number 3, driving under the influence, motor or greater. Any person who commits the offense of driving under the influence is guilty under the influence of an intoxicant is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant was driving or was in physical control of an automobile or motor-driven vehicle. 2, that the act occurred on a public road or highway. And 3, that the concentration of the defendant's blood or breath was 0.8% of 1% or greater. Count 3, vehicular homicide by reckless conduct. Any person who commits the offense of vehicular homicide by reckless conduct is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim by operation of a motor vehicle, and 2, that the defendant acted recklessly, and 3, that the killing was the proximate result of the conduct creating a substantial risk of death or serious bodily injury to the person. Count 3, lesser included. Number 1, reckless homicide. A person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Count 3, lesser included. Number 2, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Count 4, reckless aggravated assault resulting in death. Any person who commits the offense of reckless aggravated assault resulting in death is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant recklessly caused bodily injury to another, and 2, the act resulted in the death of another. Count 4, lesser included. Number 1, reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. Count 4, lesser included. Number 2, assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted intentionally, knowingly, or recklessly. Definitions. Bodily injury includes a cut, abrasion, bruise, a burn, a disfigurement, physical pain or temporary illness, or impairment of a bodily function, member, organ, or mental faculty. Criminal negligence means that a person acted with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it as it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. Intentionally means that a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Motor vehicle means every vehicle that is self-propelled, and excluding an electric scooter, motorized bicycles, and every vehicle that is propelled by electric power obtained from overhead trolley wires. Motor vehicle means any low-speed vehicle or medium-speed vehicle. Proximate result means a result which in natural and continuous sequence is a product of an act occurring or concurring with another, which, had it not happened, the result would have not occurred. Recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted knowingly or intentionally. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a bodily function, member, organ, or mental faculty. Intoxication is defined as acting under the influence of an intoxicant. The expression under the influence of an intoxicant covers not only all well-known and easily recognized conditions and degrees of intoxication, but also any mental or physical condition which is the result of taking an intoxicant in any form and which deprives one of the clearness of mind and control of oneself which one would otherwise possess. In this situation, it would not be necessary that the person be in such a condition as would require her to be guilty of public drunkenness. The law merely requires that the person be under the influence of an intoxicant. The degree of intoxication must be such that it impairs the driver's ability to safely operate a motor vehicle by depriving the driver of the clearness of mind and control of oneself which she would otherwise possess. Voluntary intoxication means intoxication caused by a substance that the person knowingly introduced into the person's body, the tendency of which is to cause intoxication, and that was known or ought to have been known. If recklessness establishes an element of an offense and the person is unaware of the risk because of voluntary intoxication, the person's unawareness is immaterial in the prosecution for that offense. Blood alcohol test. You have heard from the proof that the defendant's blood alcohol was tested for its alcohol. You've heard from the proof that the defendant's blood was tested for its alcohol content. Evidence from the test that there was at the time alleged 0.08% or more by weight of alcohol in the defendant's blood creates an inference that the defendant was under the influence of such intoxicant and that the defendant's ability to drive was impaired. If you find from the proof that the defendant was found by means of a blood test to have 0.08% or more by weight of alcohol in the defendant's blood, you, the jury, are permitted to infer that the defendant was under the influence of such intoxicant and that the defendant's ability to drive was therefore impaired sufficiently to constitute a violation of the law against vehicular homicide and or driving under the influence of alcohol. However, you are not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by the evidence in this case warrant any inference which the law permits you, the jury, to draw from the blood test result. Also, the inference may be rebutted by other evidence and circumstances. It is for the jury to determine, after consideration of all of the evidence, whether to make the inference which the law permits, the correctness of such inference, and what weight is to be given such inference. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may not be found guilty or not guilty, the defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. In reaching your verdict, you shall first consider the offense charged in count 1 of the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of each lesser included offense in order from the greatest to the least within that account. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in count one, you shall return a verdict of not guilty as to count one and proceed to the remaining indicted accounts using the same process that you used as described above in reaching your verdict with respect to count one. Some of you have taken notes during the trial. Once you retire to the jury room, you may refer to your notes, but only to refresh your own memory of the witness's testimony. You are free to discuss the testimony of the witnesses with your fellow jurors, but each of you must rely upon your own individual memory as to what a witness did or did not say. In discussing the testimony, you may not read your notes to your fellow jurors or otherwise tell them what you've written. You should never use your notes to persuade others or to influence others. Your notes are not evidence. Your notes should carry no more weight than the unrecorded recollection of another juror. You as jurors must decide this case solely based on the evidence presented here within the four walls of this courtroom. In other words, as I instructed you earlier, you should not consult dictionaries or reference material, search the internet website, blog, or use any electronic tool to obtain information about this case or to help you decide the case. Do not try to find out any information from any source outside the confines of this courtroom. When you retire to the jury room, you will first select one of your members as a foreperson who will preside over your deliberations. When you've reached a verdict, you will return with it to this courtroom and your foreperson will announce it. In order to assist you in reaching a correct verdict, a verdict form is attached to and included with these instructions setting forth the possible verdict. This form should be marked in the appropriate spaces and the appropriate blanks filled in, and the form should be signed by your presiding juror. Both the state and the defendant are entitled to your calm, unbiased judgment upon the truth of the charges in the indictment. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching a verdict if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced that it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. These instructions, along with the indictment exhibits, will be given to you when you retire to consider your verdict. You may deliberate only when all of you are present in the jury room. You may not resume your deliberation after any breaks until after all of you have returned to the jury room. And ladies and gentlemen, the jury, as I explained earlier, some of the exhibits simply can't be used by you in the jury room because we don't have electronic capability. So if you want to see another exhibit or exhibits, all you have to do is knock on the door. You'll have a court officer outside the door of the jury room. Let them know that you want to see exhibits again or review as many of them as you want to, as often as you want to. When that occurs, then you'll be brought to the courtroom. You will be displayed or given opportunity to review any exhibits that you want. You will not be allowed to say anything or to deliberate in the courtroom, because essentially what I'm doing is I'm turning the courtroom into the jury room at that point in time. Once you've then viewed whatever exhibits you want to see again for as many times as you want to see them, then you'll return to the jury room and discuss what you've seen. Do you all have any question about that procedure? And one thing I might add as well, if you get to the jury room and you find that you want more than one copy of the jury charge, just let us know and we'll make as many copies as you want. You will be given the charge as I've indicated when you retire to deliberate. Sometimes jurors would like to have more than one copy. Sometimes they want a copy for each juror, and that's perfectly fine as well. Now let's look at the verdict form together. This is your verdict form, and you'll see if you compare the verdict form to the order of consideration portion of the charge, then you'll follow that instruction. You'll first consider the indicted charge, make a decision on the indicted charge. If your decision then is not guilty by reason of reasonable doubt as to guilt, or because you find the not guilty verdict, then you'll go to the first lesser included and repeat that process. Once you reach a decision going down the ladder, you'll stop at that point in time. As I mentioned earlier, if you find the defendant not guilty of all of the charges that are included in the indictment, then your verdict for count one would be not guilty. And you'll repeat that process for each count in the indictment. So you have count two with each lesser included offense in count two, count three, and so on. At the end of the form, there is a place for the presiding juror to sign the verdict form and to date the verdict form. Does the state of Tennessee have any addition, correction, change, or deletion to the charge?
No, Your Honor.
Very well. Does the defense have any addition, change, correction, or deletion to the charge?
No, Your Honor.
Very well. Let's bring up our lights. And Ms. Gray, you can take the charge down. Is the state of Tennessee ready to argue?
Your Honor, the state needs approximately 5 to 10 minutes to arrange the courtroom in a manner as to argue.
All right, then it'd be, we'll just allow the jury to retire, and we'll bring you back just as soon as the state is ready to proceed.
Get the television. Yeah.
Please be seated, everyone. Mr. Colmore, just come get me when you're ready.
Your Honor, one moment.
Yeah.
Just so the court is aware, the state is going to use a PowerPoint in its first close. In the past, I've run into issues with defense counsel being able to see the PowerPoint, obviously, because it's being projected to the jury. I'm copying an exact copy of the PowerPoint onto a flash drive now to provide to the defense so that they can view it at counsel table while the argument is occurring.
Mr. Brand, is that acceptable? Otherwise, you can move over and try to look at it, but it'd be difficult with the configuration of the courtroom for you to do that. So if you can look at it at your table with your computer, it will be easier for you.
All right, that's fine.
All right, very good. That's what we'll do.
Thank you. I'm done. Yeah. Okay, so I'm going to need the television on one side and the podium on one side. However, that's easiest to configure. And I'd like them to be kind of angled so I can see the television.
Let's get this out here. Oh, Lord.
Yeah, that's fine. Thank you. All right, now we just got to make sure this. And I'll do my best to make sure this can kind of face the gallery. Okay, are we turned on? Can you make sure it's on VGA? Yeah. All right, leave it on for a second.
attorney remain seated.
Mr. Hess, is the state ready to proceed?
Yes, Your Honor.
Very well. Is the defense ready to proceed?
Trying to get out of exhibits.
You got stuff. Just keep them all here.
Ready to bring in the jury? Mr. Hoffman, are we ready to bring in the jury? All rise. Thank you, everyone. Please be seated. Mr. Hess, proceed when you're ready.
Thank you, Your Honor. Ms. Kroese is charged in a 4-count indictment. The state has proven each of those charges to a moral certainty. Count 1, vehicular homicide by intoxication. Count 2, vehicular homicide with a blood alcohol concentration of 0.08% or greater. Vehicular homicide by reckless conduct. And count 4, aggravated assault resulting in death. Let's begin with this simple conclusion that's stated to you in your jury instructions. When you evaluate these charges, quote, the crime charged in each count of the indictment is a separate and distinct offense, right? You must decide each charge separately on the evidence and the law applicable to it. So you look at each charge in a vacuum and determine whether or not the evidence fits to the elements, okay? And remember, you do not set the punishment. And you'll notice that multiple counts of homicide are charged, right? The state has asked you and will ask you to convict her of all. But if and when you do, they will all merge into one offense because only one death occurred here. They'll all merge into the most serious offense. We're not asking you to put her in a position where she's sentenced on multiple counts of homicide, right? Only one person died here. She's guilty of all of these charges, but they'll merge into one offense when you convict her of all 4. Count 1, vehicular homicide, intoxication. There are 3 elements to this offense. 1, Ms. Kroese killed Officer Legieza by operation of a motor vehicle. Obvious, right? I mean, that unequivocally happened. 2, she did so recklessly. 3, Officer Legieza's death was the proximate result of Ms. Kroese's intoxication. Let's talk about this. What does recklessly mean? This is directly from the jury instructions. Recklessly means she was aware of but consciously disregarded a substantial and unjustifiable risk that circumstances exist or a result would occur. In order for her to have acted recklessly, she would have had to consciously disregard either one of these things. The circumstances being how much she had to drink and how that would affect her ability to drive. Those are the circumstances. The result being death to another on the roadway, right? So if she consciously disregarded the risk of either one of those, that element has been established. Not consciously disregarding the fact that that would happen, right? Merely consciously disregarding the risk of that happening. Her ability to drive being impaired or someone dying as a result. Merely disregarding the risk of that establishes that element of recklessly. And obviously it happened, right? It happened. The death of Officer Legieza was the proximate result of an act. Okay? The state has to prove that his death was the proximate result of an act. Proximate result is defined as the product of an act which, had it not happened, had the act not happened, the result would not have occurred. In this case, the act being Ms. Kroese driving, and the result being Officer Legieza's death. Easy enough, right? Had Kroese not driven, Officer Legieza would not have died. Proximate result. And what this entire case comes down to right here. The result, the crash, the death, must have occurred by intoxication. Now, count 1 of the indictment, intoxication, is defined for you as it had to have impaired her ability to safely operate a motor vehicle by depriving her of the clearness of mind and control of herself, which she would otherwise possess. Let's look at the evidence of lack of clearness of mind in this case. All right? Let's look at her driving behavior. Driving without headlights. Remember Ms. Hawkins, a defense witness, mind you, a defense witness. And that's an underlying theme of this case, which we'll get into in a moment. Ms. Hawkins, unsolicited, this is a really dark stretch of road, and the state asked her, would you have noticed if you didn't have your headlights on at that time of morning? And the look on her face was the most obvious question of all time. Yeah, I would have noticed. It's 4:50 in the morning on a dark stretch of road. Yeah, I would have noticed. Driving without headlights. Driving on the wrong side of the road completely, right? We're not talking about swerving. We're not talking about crossing a center line or a fog line. We're not talking about weaving within a lane. We're talking about driving completely on the wrong side of the road. Stopping in the middle of the road. Literally coming to a complete stop in the middle of the road on Main Street. That probably goes to the last point, which we'll get to in a moment. No braking before impact. None. Even though Officer Legieza had his headlights on. No braking. Go back to what Special Agent Ogilvy talked about divided attention tasks and how alcohol affects our ability to divide our attention. No swerving before impact. This last fact was offered by the defense. The proof in this case is so strong for the state that even when the defense elicits testimony through Officer Sergeant McCauley about the Google Map data, it's a good fact for the state. She Google Maps how to get to her house south of Franklin. So A, she drives the wrong way to begin with. She goes north when her house is south. And B, she can't even follow the map to her house. She plugs that in at 4:41. That's what the records show. Accident happens 10 minutes later. So for 10 minutes, she can't even follow the Google map direction to her own house. This is just another example of an underlying theme here, that this case being so strong that even the defense witnesses, even the proof elicited by the defense, helped the state. Let's look at non-driving behavior. Jessica Hortner-Simon's testimony that she was worried about Kroese's sobriety. She said she would have left Kimbrough's much earlier than 4:30 a.m. had she not been worried about her sobriety, right? She offered her an Uber, and she discussed it with Max Jordan. Another defense witness, the other bartender, Jennifer Pramuk, another defense witness, consulted with Max Jordan about calling her an Uber at 2:30. These were the two bartenders at the bar she was drinking at. The two witnesses, through testimony elicited by the defense, that were trained in ABC techniques to determine intoxication, right? The two people that were trained to determine whether or not someone was intoxicated. Yeah, we talked about getting her an Uber. Why else would you talk about getting someone an Uber? Really? Let's talk about her drinking behavior. At least 7 drinks between 7:30 p.m. and 4:30 a.m. So you've got the 15 glasses of wine, or excuse me, not the 15 glasses, the 15 ounces of wine at Americana Tap House, the 6-ounce glass of wine at OB Joyful, the whiskey drink at OB Joyful, Jack and Coke at Kimbrough's, Miller Lite at Kimbrough's, Corona at Kimbrough's. All she had to eat was all she had to eat was ice cream, fries, maybe some chips, right? That's all we know for sure. And of course, you know that's not true. You know that's not true. Because the blood results tell you a different story. And the blood test in this case is the only concrete scientific evidence of how much alcohol she consumed. It is the only scientific and concrete evidence of the amount of alcohol she consumed. And the validity of that test, the accuracy, try as Ms. Kroese might, and she did try to attack the validity and the accuracy of that test. She didn't. It's completely unrebutted, the accuracy of that test. You know that she was twice the legal limit. You know it. So you know that's not all she had to drink. Finally, as it relates to impairment in count 1, you can draw an inference of impairment solely based on the blood test. So you throw everything else out the window. Driving on the wrong side of the road, driving without headlights, how much she was swerving, et cetera, anything to do with driving behavior. Her stopping in the middle of the road, her not knowing which way's north, which way's south. Throw all of that out. You can infer impairment based solely on the blood test. Now add the blood test into everything else you know. How much more does that bolster the fact that she was impaired? You can base an inference of impairment based solely on the blood test. Ladies and gentlemen, is this a result of clearness of mind? Is that a result of clearness of mind? Is that a result of clearness of mind? Does a driver with clearness of mind do this? Not in the median, not straddling a line. Completely in the wrong lane of travel. Not even in the turn lanes. Completely in the wrong lane of travel. Does a driver with clearness of mind do that? Does a driver with clearness of mind do this? Officer Legieza is entirely within his lane of travel. He never sees her. Never sees her. Entirely within his lane of travel. Count 2, vehicular homicide, .08 or greater. Elements 1 and 2 are the exact same. Element 3, Officer Legieza's death was the proximate result of Kroese's intoxication of 8/100ths or greater. .166. .166. Alcohol dissipates from the body at what? 0.01 to 0.02 grams per cent an hour? Blood was taken at 556, around there. What was she at 450? Not a 166. Count 3, vehicular homicide, reckless conduct. This is an even lesser standard than counts 1 and 2, right? This is even lesser. This is easier to prove. She killed Officer Legieza by operation of a motor vehicle, and she did so recklessly. And his death was the proximate result of conduct creating a substantial risk of death or serious bodily injury to a person. Now, this word conduct, right? That's the key. This laser pointer would work. This is the key here, conduct. What is the conduct? That conduct in this count could be established by any number of facts, right? The conduct could be how much she had to drink. The conduct could be her driving in the wrong lane of travel. The conduct could be her driving with no headlights on. Any one of those things is conduct creating a substantial risk of death or serious bodily injury, right? So that's even a lesser standard. And count 4, which I will spend approximately 2 seconds on because it is about as obvious as it gets, right? She caused bodily injury to Officer Legieza and it resulted in his death. They're going to stand up here and they're going to talk about her blood. It's just what's going to happen. Okay? Try as they might, and they tried, and they tried, and they tried to attack the validity of this blood. But it's obvious it was her blood. You know it was her blood. You heard Allie Osborne's testimony about her ordering the blood draw. You'll see the label on the tube with her name on it. The accession number matches up with it. It's her blood, right? They're going to stand up here and try to say it wasn't. The tubes, the tops of the tubes, When that argument fails, when that argument about it not being her blood fails, what are they left with? What are they left with? What is Miss Kroese left with? Some people that saw her that night didn't think she looked impaired. That's it. That's the defense. That is the defense in this case. Some people she was with didn't think she looked impaired. That's the entire defense. Now let's consider the credibility of these people. The 2 bartenders who trained in ABC training were concerned enough, right? The 2 bartenders with ABC training were concerned enough to offer her an Uber, to give her water, to stay 90 minutes past close in Miss Hortner-Simon's case in an attempt to make sure she was okay to drive. In Ms. Pramick's case, concerned enough to consult 2 hours before Ms. Kroese left with the owner's son, Max Jordan, about, hey, maybe we should get her an Uber. Now, Amber Barker and Justin Woodley, they weren't concerned with her sobriety. They left 2 hours before she did, though. Right? But they were drinking with her all night. They left at 2:30, more than 2 hours before Ms. Kroese left, right? So what does it come down to? Who are these 2 witnesses, these witnesses that say she wasn't impaired, right? Max Jordan, the owner of the bar's son, and Austin Ailes, a current employee of the bar who never had an interaction with her the entire night. Never spoke to her, never had an interaction, but he can remember everything she said, he can remember everything she was wearing, he can remember everything she did, what she drank. The 2 witnesses that essentially say she looked okay to us were employees at the bar where the girl that drank too much killed the police officer. That's the defense. Ignore the driving. Ignore the blood alcohol. They didn't think she looked okay. You've all been around people who have had too much to drink, right? You've been around people that are drunk. You've been around folks that are buzzed. You've been around folks that are impaired. You know that people manifest intoxication in different ways. It's just a fact. It's a fact from your everyday experiences as human beings. People manifest intoxication in different ways. Some people slur, some people stumble, some people get happy, some people get sad, some people get mean, right? By all accounts, Ms. Kroese didn't seem to stumble or slur, even though these folks never even met her before, right? They don't know what she sounds like or walks like, right? But this is what she did, okay? This is what she did do. She made decisions that show you that she was impaired, okay? That show you that her clearness of mind was impaired. She drives without headlights. She drives in the wrong lane. She drives in the wrong direction to get home, and even when she Google Maps it, she still can't go the right way. She doesn't take up Miss Hortner Simon's offer for an Uber or a cab. She drives home. She drives home. She drives home. It's as simple as this. It is as simple as this, and this is what the evidence tells you in this case. You know it was her blood. You know she was drinking that night. You know she was twice the legal limit. And you know she killed Officer Legieza because of it. It's as simple as that. The only reason Destin Legieza is dead, is because Ashley Kroese consciously disregarded the unjustifiable risk to others on the roadway by driving that morning. The only reason he is dead is because she decided to drive. During jury selection in this case, the state told you that the fact that Destin Legieza was a police officer cannot influence your decision, right? And it can't. It cannot. And it shouldn't. And the state is not asking it to influence your decision. But the fact of the matter is this. This man put his life on the line every day. Every day. He didn't die serving an arrest warrant on a violent criminal. He didn't die protecting a domestic assault victim. He didn't die running to the aid of a trapped motorist on the interstate. At least in those cases, he would have known what he was getting himself into. That's why he signed up for this job, right? He would have at least had a decision. He would have known what was potentially coming. He died driving down the road an hour before his shift was supposed to end. And he never saw it coming. He never saw her coming. Hold her accountable.
Does the defense care to make a closing argument?
Yes, Your Honor.
Feel free. Mr. Aiken, that may be Mr. Hess's pen on the
Sure it is.
on the podium.
Probably my water as well. Thank you.
Your Honor, if I could have a second to hook up.
Certainly. Take your time.
Can we just use this screen? Connect to that?
Well, yeah, you have a VGA adapter. I use VGA adapter.
You want to adjust this podium?
No, I don't think this has any connection input to the television. It might, you can figure it out. I don't know.
Move it up in here. Just keep it here. That's all right. Whatever you want. I don't know.
And Mr. Hoffman, you may want to lower that mic a little.
I'm sorry?
You may want to lower your mic a little.
Is that okay?
That'll work.
Good afternoon. We're supposed to tell you that we enjoyed having you here. You're here to deliberate on a very, very important matter. I don't have to tell you that, both for the Legiezas and for the Kroeses. I don't have to tell you that. And if it was as simple as the state would say, it's obvious, it's obvious, it's obvious, I wouldn't have to be here. Obviously, the only thing obvious is that I don't agree with you. I don't think this case is an obvious case of intoxication with an automobile operation. I don't think that Ms. Kroese had bad judgment that night.
Could I have a sidebar?
If everything was so certain, if it was that easy, the law wouldn't be instructing you that when an expert, whether it's Ms. Ogilvy or anybody else, Ms. Ogilvy happens to be the expert with the blood test, you're going to get an instruction from the court that you can believe her or not. If it was so certain, that instruction probably would not be there. Again, it's going to be up to you to determine who's telling the truth. That's what a jury does. This is a truth-finding exercise that we're engaged in right now. Both sides are claiming they're telling the truth. And they may be. But you're going to have to decide which side you want to believe. And that's your job. The defense believes your job is not going to be that simple. This is a case about drinking. And in Tennessee, you can drink and drive. That's the law. You can go out somewhere, whether it's a restaurant or a bar or a friend's home or a party. You can have drinks. What you can't do is get in your car after drinking and drive while you're under the influence. And who determines that? Who determines whether you're under the influence? The defense would say a police officer does. The normal way of getting caught, DUI, is you're driving, you're weaving, you're doing something erratic. You're noticed by the police, you get stopped, field sobriety tests. Police officer says, you're under arrest for DUI, I want you to give me a blood test. And that blood test is important. And if a person says yes, they go to a hospital. You heard the procedure from Trooper Newenhouse. They take them to a hospital, get a nurse to take the blood. The officer watches the blood go into the arm, the needle, and watches the blood come out of his suspect. Ask him, why do you do that? Why do you watch? So I can testify in court that it's her blood. I take the blood after it's drawn and put into two tubes that I gave to the nurse, and I put it into this box, this TBI kit. The kit was opened for you. You saw it. You know what's in it. The two tubes go into this box. The officer saw the blood go into the box, and what does he do? Takes the tape of the box and tapes the top of the box to the bottom of the box. Why do you do that, officer? So there's no tampering. What do you do with the box? I either take it to the TBI crime lab or we send it by mail. When TBI gets it, they have a special person, a receiving clerk. This is how technical and specialized this operation is, this procedure, this protocol. This receiving clerk takes it, opens it, documents it, anything that's unusual she notices, but because the TBI crime lab itself prepared this kit, they know what's in it. It's just the person's blood that the officer saw go in there, and it ends up in the lab. If that were done here, I wouldn't be talking to you about breaking protocol. The protocol normally is that they take the blood and someone like Miss Ogilvy tests it. The test is recorded on a report, which you will see. And that's the blood test. Now, what role does this officer play? A police officer. Y'all know what a police officer is. What role does he play in this DUI, this drinking business? Normally, he's the one that catches you driving in a certain manner that most people would identify as driving erratic. Or you can identify driving on the wrong side of the road erratic. I think that's common, plausible. Driving without headlights. Something everybody's done. Imagine someone that goes to a friend's house, has one drink, forgets to turn the lights on at night, drives home, happened to cross a line, and police saw him. Now, he only had one drink, but he's done everything that the DA has argued would constitute driving under the influence. Is that person intoxicated? You know it's not. You heard the operator, Ms. Ogilvy, say that as you drink, you also eliminate. Now, I'll get to that in a second, but getting back to the officer. The officer plays a huge role in a normal, typical DUI. What about here? What about here? How many, not only officers, how many police agencies, Brentwood Police, Franklin Police, THP, there's 3 law enforcement agencies that were out at this scene. And how many officers were involved? 15, 20, 25? You saw video. You heard testimony. What were they doing out there? These are trained people to recognize indicia of intoxication. They weren't just running around like chickens without a head on. Had they seen evidence out at that scene, you would be hearing about it. Had Ms. Kroese been the irresponsible driver that the state says she is, probably would have had some evidence of alcohol in the car, but no one saw it. I don't want to go through everybody that said they didn't see it, but no one saw it. And in this case, a police officer didn't see it. There is no police officer to testify to her intoxication. Yeah, they didn't see the wreck. This is not the first time police show up at a wreck that they didn't see. But when they see evidence of alcohol at the scene, and you know it's a crime scene, you heard that testimony, nothing. There was no evidence of a crime at the scene except a car wreck. Even their own expert, the only thing he could testify to was that Officer Legieza was not belted, his seatbelt was not on, and Ms. Kroese's seatbelt was on. That's it. You didn't hear anything about being intoxicated. And the state wants you to believe that just because she did what was legal in Tennessee, and that's drink and drive, that all of a sudden, because of the drinking, she's intoxicated. And you know better than that. You can drink and not be intoxicated. Yes, that video at Concord Road showed her driving on the wrong side of the road. But I would ask you to look at that video again. Look at her driving. That looks like conscientious driving on the part of the driver. Look how steady that car is driving. Yes, it's on the wrong side of the road, but you have seen a video of Officer Hartman's journey, the same journey she took from Moore's Lane on Franklin Road to Concord Lane. You saw that, and that journey that that officer took was just minutes after this wreck. Look at that video if you would and see the condition of the road. traffic barrels, signs up, the lines in the road were unclear. It was a road under heavy construction, ladies and gentlemen. It just wasn't a road. Now, there's an area that the defense believes we don't know. There's an area where we believe she might have crossed. We do know this. We do know this. The evidence showed it's about 6 miles from Franklin to the Brentwood Market. So between Moore's Lane and Concord Road, you've already come at least 70%, 75% of the way. We don't have any evidence of bad driving. Now, we don't have any evidence she had her lights on. I can't explain how someone could drive in that darkness over that road in the condition that it's in. I can't explain how they can do it. I don't know. But it would seem logical to me, seems logical to anybody, that if you can drive in that condition without your lights, you've got to be pretty much aware of what you're doing. And if she's looking at her GPS, which evidence shows she was, at different times during that journey, she was looking at her GPS. A condition that most people know about. Most people today use GPSs to get places. The evidence shows she was using a GPS. She was lost, according to the evidence. But she made it through fine. I ask you to look at the video at Moore's Lane, where she approaches cautiously, where the light is changing. She slows down as it's changing. The light turns green for her, and she speeds up, crosses, she's in the right lane, her lights are still off. Look at that driving. Is it because her lights are off that the argument is she's got to be DUI? Because in Tennessee, the law is you can drink and drive. Her driving at Moore's Lane was fine, except that she did not have her lights on. I can't explain that. When she gets to Concord Road, she's in the wrong lane. You see her crossing Concord Road in the wrong lane. Franklin Road. I don't know what happened between Concord Franklin intersection and the Brentwood Market, but she was obviously in the wrong lane when this accident happened. Did her driving prior to that wreck show a complete lack of attention to what she's doing? Did she have so much alcohol in her, according to the evidence, that her intoxication caused her to act reckless with her automobile to kill this officer? Well, in order to answer that, you have to go back to when this all started to see what she had to drink, because that's what this case is about. Witnesses versus .16. That's it. And when you go back to the very beginning, you see her parking her car around 7:30 in the evening on Franklin Square. She comes around the square, it's still daylight, 7:30, she parks her car, no problem. She gets out, and according to the evidence, she goes to the tap house, Americana Tap House on Main Street. I don't want to go through all the things that happened there. You've heard it. You've heard the testimony. She came in, she had the 9-ounce and the 6-ounce glass of wine, and she and her friend left. But while she was there, she made an acquaintance with Amber Barker. You heard from Amber Barker. We'll get to her in a second. Amber Barker suggested to her that maybe she might want to go to another place, and the defendant may have asked her, is there any other place we can go to, because she was not familiar with Franklin. Amber suggested, why don't you try Oh Be Joyful? And she did, and met Amber and her boyfriend there. Again, she had a drink. There is a question of whether she drank a Vauquerie. Now, you didn't hear evidence that she drank a Vauquerie. You heard evidence that Amber ordered her one because Amber was drinking one and wanted to see if she liked it. There is no evidence that she drank it. Now, we included the Vauquerie when we asked the forensic scientist at TBI to calculate the blood alcohol content. And even with that extra Vauquerie, if she drank it, she still would not have been over the legal limit of 0.8. That's what she said. And the evidence showed that Ms. Kroese and her friends decided to go to Kimbrough's. Again, Amber Barker was going to Kimbrough's. Now, ladies and gentlemen, just because somebody goes to 2 or 3 bars, if you have evidence they're getting drunk, you're going to have evidence. You're going to hear about them stumbling or some form of imbalance. You're going to hear evidence of slurred speech or couldn't concentrate. You're going to hear evidence of someone getting loud or picking a fight. The normal indicia of people that drink too much and can't hold their liquor. You never heard any of that about this young lady. You never heard anything except that she acted like a lady. She did not act like a drunk. And that's not acting. There's no evidence she drank to be a drunk. When she came to Kimbrough's, according to the testimony you heard, she was sober. So she was sober after she left Oh Be Joyful. That's the state's own witness, Miss Amber Barker. And then when they get to Kimbrough's, the state is trying to paint Kimbrough's as a dive or something like that, staying after hours. Kimbrough's has been around for years. It has been around since Franklin has grown to be the great city it is today. Max Jordan is a believable witness. He told you he doesn't drink. Doesn't drink. A young man like that doesn't drink. He went there to meet 2 friends from church. That's what he said. But his dad owns the place. Will Jordan owns the place, and his son is the manager. He went there around 11:30 or 12 that night. And he said he happened to see Ms. Kroese there. And then both of them had this French connection where Ms. Kroese saw a tattoo, a French flag. They talked for a while. Nobody said that Ms. Kroese got intoxicated. Nobody except Jessica Hortner. The woman who came up to this stand and couldn't even remember the questions I was asking her, and then couldn't remember the answers. The woman who sounded unbelievable. The woman who has a reputation for drinking on the job. The woman who says she went to Max Jordan that night late and said, we need to take care of her. She's intoxicated. And when I called Max Jordan in here and put him on the stand the second time, I said, did that happen? Did Jessica tell you that we need to take care of Ashley because she's intoxicated? Max said no. Jessica Hortner is not believable. And I submit to you that Amber Barker is not believable because Amber Barker admitted she got drunk herself that night. I don't want to go through all of her testimony, but basically Amber Barker was out to have a good time that night, apparently did. And if she said anything about Ashley Kroese's intoxication, you cannot believe it because she admitted she was intoxicated. She was drinking. That's the people that the state is relying on to let you decide whether or not Ashley Kroese was intoxicated that night. So what do we have? We have no evidence so far that Ashley Kroese was intoxicated. But we have more evidence than that. The night's not over. Because when 4:30 came around in the morning, the evidence showed Ms. Kroese had not been drinking for 2.5, maybe 3 hours. Not to sober up, ladies and gentlemen. She was having fun with people socializing in Franklin. Is that so hard to believe? Is that impossible to believe that a young lady can go to a bar and actually enjoy herself without making a fool of herself? I don't think it is. I think that's what we all want. We want someone to act like Ashley Kroese acted that night. We don't want someone being a drunk. And to show you what I'm talking about, you've seen a video of Ashley Kroese leaving that place. You saw her walk down 2nd Avenue with Max, and she was in high heels. You saw her walking without stumbling. There was nothing unusual about her mannerisms in that video. You also saw Max walk her up to the car. He was the last person to see her before this tragic incident. And what did Max tell you? Max told you that she was not intoxicated or he would not have let her leave. So the very last person that night that saw her said she was not intoxicated. Of course, the state is going to somehow say Max is lying. You heard him. You saw him. he's a resident here with a family. You decide. But the defense believes he was telling you the truth. She gets in the car. This is on video. Gets in the car and gives a signal to get out, that she's pulling out, which she does, and forgets to put on the light. Now, if she never had a drop to drink, you certainly couldn't argue that forgetting to put on the light was caused by her intoxication, right? No proof. But because she had a drink, which was illegal, the state argues that she was intoxicated, and that's why she didn't turn on the light. However, when you see her driving on Main Street, she's driving fine. She just doesn't realize her lights are not on. The implication is she just wasn't thinking about the light. And that's happened to many people. Now, once she leaves Main Street, there's no video. There is a video on Moore's Lane. Now, I've already talked about that video. That indicates she was driving fine. And Moore's Lane is 4 minutes away from Concord Road, according to Google. And Google takes into consideration the construction, which is, at that time you heard, 35 miles an hour. So she was 4 minutes away from Concord Road when she was at Moore's Lane. And according to the video the state has, it took her 4.5 minutes to get there, to get from Moore's Lane to Concord Road. She was traveling less than 35 miles an hour through that construction. Now, I don't know how it happened that the state expert, who you don't have to believe, says she was traveling at 58 miles an hour at the time of the crash. We don't have any evidence to the contrary. But it is not logical that she's traveling below 35 miles an hour for almost 4 miles and some odd seconds on a clock, and then all of a sudden speeds up. I don't know if that happened. The expert says it did, and I can't prove it didn't. All I can say is she came a long way and made it. And now the state wants you to find her guilty of killing this young man because she was drinking, when the evidence shows she was not intoxicated. Now, I don't get to come back up here and refute whatever Mr. Hess is going to say. Mr. Hess, by the way, is a fine attorney. I wish I could get back up here and counter what he's about to say, but I can't. So I got to say it right now, and that's it. And what I'm telling you is this. The blood test that was argued to you to be unrefutable is refutable. If it wasn't refutable, you wouldn't have that instruction of inference, that you can infer when you have a .08 or greater, you have the right to infer that she was intoxicated. But if you find that there's evidence to rebut, to contradict that .16, you ain't got to believe it. And when you look at the evidence in this case, the defense believes you shouldn't believe it. I mean, look where the blood came from. You can't do it. Yep. Nothing seems to work for the defense here. This is where the blood came from, ladies and gentlemen. This is where it started in this case. This is where the blood that came up with a .16 came from. Look at that picture, please. This is going back to the jury room with you. And what was the evidence? What was the evidence as to how this came to be? It didn't come to be with the typical way a DUI starts, and that's with a police officer taking the person to the hospital and giving them the nurse the blood kit. Nope, it didn't start that way. It started with the police coming to Vanderbilt. Coming to Vanderbilt and getting 4 blood tubes. Exhibit 25. This is what Vanderbilt gave the officers to show them, there's 2 of them, to show them what Vanderbilt was giving them. The officers signed for it, and so did the lady that gave them the 4 tubes. She gave it to them in a Vanderbilt Ziploc bag. And the officers signed it, and it said that there was 1 lavender top. We know that that's a tube top on one tube. There was 1 green tube top, 1 serum, which turned out to be the red tube top, and 1 light blue. Now, don't you find it curious that when the officers took a hold of this Ziploc bag with these tubes in them, they didn't bother to look inside to check. They didn't check it out and see if these tubes are tubes that he might want to take, because normally he has tubes that come from this. Normally this right here has gray tops. And he knows what that means, doesn't know what this means, but they didn't care. They didn't check. They just took the bag, and as Trooper Newenhouse testified, he took the bag, put it into a TBI kit, put it into the kit. He emptied out the contents and put it into a kit, made this a luggage. This became a luggage in this case, and that's what he took to TBI. Now, the evidence showed that those 4 tubes, nobody knew who got them into those tubes. The person who collected that blood is unknown. In a regular case, that person who collects the blood has to sign off on the alcohol request form. This form right here, Exhibit 26, that's why you got this form. It's protocol that if we're going to be able to identify whose blood that is in the tube This request form requires that you put the time of collection and the name of the person who collected the blood. Didn't happen in this case. That protocol wasn't even observed. So we don't know who collected it or what time. Now, speaking of the time on the tubes, and you're going to see pictures because somebody took pictures of those tubes. You remember correctly. The time on the tube is 0556 or 5:56 a.m. Ladies and gentlemen, you have evidence of the medical record. That time of collection does not exist in the medical record. You've got the records, you can look at it. I think it's page 95. Now, the state comes in with Mrs. Osborne, who is a nurse at Vanderbilt. And of course, she wouldn't be protecting Vanderbilt's reputation any, but he brings her in, and she testifies that that was the time that she believes she did the labeling. That's not what it says in the record, but that's what she says as an explanation for the .0607. Now, you might want to say, well, what difference does it make, whether it's .0556 or .0607? Makes a difference to this young lady. It makes a difference to this case because Vanderbilt is so exact, science is so exact, and here we have two different times. And the question is that her blood? We don't have the person who drew it. We don't know when it was drawn. Yes, we have a label. I suggest that that is not enough. And even worse, you recall when I said typically that the officer watches the blood go into the arm and then puts it into the kit and on and on. Here, you don't know what happened when the blood was drawn. In fact, Ms. Grady, who works in the lab, said she don't know how many people handled it. She don't know who handled it. She told you that each tube was tested, but she doesn't know anything else. And then when the lab, and by the way, she also said, when I said, is this the way you gave the tubes to the police officers? Were they in this condition? Because this is what condition they were in when they arrived at TBI. What'd she say? I don't know. It's a serious case. People's lives are involved here. And she can't say whether this is what she gave the police officers to take to the lab for testing. That's incredible. It doesn't happen in a typical case because if they follow protocol, they eliminate these type of mistakes. This case is a classic case of mistake after mistake after mistake. This case is the reason you have protocol, so that this won't happen, so that that .16 will be a clean example, a clean blood draw, and a clean blood test result. Clean. That's not clean. So how do you know? How do you know that that .16 is reliable? Defense admits you don't know. You're just guessing. And not only that, But I asked Miss Ogilvy, I said, I'm going to give you a history. I'm going to give you a history of this drinking. I don't know if it's right, but we showed you bar tabs to support it. Remember? 3 bar tabs that came into evidence. Yeah, you can speculate that somebody bought her a drink here or there. There's no evidence of it, and you're not allowed to speculate. But I said, what happens if she has the drinks that are in the bar tabs? What would her alcohol blood level be at the time of the wreck? What'd she say? She calculated. She did a math calculation that's supposed to be reliable, just as reliable as her blood test. There's no evidence it's not as reliable, and her calculation in front of you was that the blood alcohol content of Miss Ashley Kroese at the time of the wreck was 0. Wasn't it? That's what she said. Of course, the state's got to bump it up a little bit, so they're going to say, well, what if somebody? Well, you don't have evidence that somebody. And I even asked Miss Ogilvy about the extra questionable drinks that we're talking about, the Vucari and another drink at Kimbrough's. And she said wouldn't be enough to get her to 0.08. The .16 is not reliable. The .16 in this case, as the instruction said, is an inference that has been rebutted. You cannot rely on it. From the evidence that you have heard, that blood test is unreliable. From the evidence that you've heard, a young female walking down the street in high heels and not stumbling, not making a fool of herself, not slurring her speech, not doing anything that requires someone to say, well, maybe she's intoxicated. No, maybe she was drinking in Tennessee as the law requires. That's what she did. Now, if you find that she's reckless because of what she did, but not by alcohol, if you find that her going into the other lane was a reckless act, that she knew the risk she was taking, I submit she did not know the risk she was taking by looking at that video I asked you to look at and seeing how she travels. So, if you find that that is reckless, so be it. But what the defense argues strenuously is that she was not intoxicated at the time of the wreck, and we ask you to find her at least as to counts 1 and 2 not guilty.
Does the state care to make a rebuttal?
Yes, Your
Does the jury need a break? We've been at it right at 2 hours.
Honor. I'll be quick. It won't be more than 10 minutes.
Are you all comfortable that long? We'll proceed. Thank you.
Yours? Yep. Okay.
Look, the defense's closing argument is what it is, right? It's all they have. Some of what Mr. Hoffman just said was supported by the proof. Some of it wasn't. You remember the proof. You can consult your notes. You remember the testimony. You'll be able to consult the exhibits, and you'll be able to determine what was said and what the facts of this case were. But it played out like the state said, and it's open and closed, didn't it? Played out just like the state said. The people she was with, some of the folks that she was with, didn't think she was drunk. Some of the people that saw her that night didn't think she was impaired. If Max Jordan being a credible witness is a strength of the defense's case, that should tell you all you need to know. And it finally came out, right? It finally came out. It finally came out because they know that this whole argument of, oh, these bartender, the folks that work at Kimbrough's didn't think she was right. It finally came out. This isn't her blood. This is not her blood. This is not her blood. Finally came out. One of these things is true, and one of these things is not true. Either Ms. Kroese had more to drink, or this isn't her blood, right? Either she had more to drink, or that's not her blood. One of those things is true, and one of those things is false. Which one's more logical? Which one's more logical? Based on everything you know, what is the more logical answer there? What is the more reasonable answer there? That this is not her blood? Who would you rather come in here and tell you about drawing someone's blood? A Tennessee Highway Patrolman or a nurse at Vanderbilt? That's their argument. That's their argument now. State didn't even think they would even try to go there. This is not her blood. Consider all the evidence you've heard in this case over the past 3 days. All of it. When the defense made an opening statement to you, they said, and the state agrees, the issue in this case is, did alcohol cause this crash? Did alcohol cause this crash? That is the issue in this case. Think about all the evidence you've heard over the past 3 days. What other conclusion have you been presented with? What other conclusion could you possibly arrive at? She was drinking all night. She was a .166. She was driving in the wrong lane. She was driving without headlights on. She was kept at the bar to try to sober up. She was driving in the wrong direction of her home. Did alcohol cause the crash? It is what the proof has shown since the moment the state started calling witnesses until the moment the state rested, and even when the defense started calling witnesses. The state's case continued to get stronger. It is the only conclusion that you can arrive at. Did alcohol cause this crash? Yes, undeniably yes. When you leave this courthouse, will you be morally certain of your decision? When you leave this courthouse and you lay down tonight, will your mind be able to rest easily as to your decision to convict Ms. Kroese of vehicular homicide? It will. It will. And it will because all the facts and the evidence in this case give you that power. All the facts and the evidence in this case give you that moral certainty. Because remember, while moral certainty of guilt is required, absolute certainty of guilt is not. Absolute certainty of guilt is not. But this is what is absolutely certain. It is absolutely certain that Destin Legieza is dead. It is absolutely certain that he died in front of his best friends who could do nothing to try to save him. And it is absolutely certain that she is the reason why. Because she decided to go out drinking for 9 hours and get behind the wheel of her car. with a blood alcohol content more than twice the legal limit. That is what is absolutely certain. And she decided to drive north. She decided to drive north towards the Brentwood Market and Deli, towards Officer Destin Legieza.
Thank you. Ladies and gentlemen, you've heard all of the evidence now. You've heard the arguments of counsel. Ms. Gray has put your name on a little slip of paper and folded them up so that I can't see whose name is on each slip. So by blind draw, I'll select our 4 alternates. Ms. Pierce, you are excused. Mr. Callmore and Mr. Aiken, of course, are your court officers. They'll be available for you. They'll collect the exhibits that you can use in the jury room and make those available. They'll be outside your door. Just knock on your door if you need something. Remember, if you take a recess, you're welcome to do that. Just do not talk about the case when you're in break. You can only discuss the case when you're together. And then at the point where you reach a verdict, let us know and we'll bring you back in so that you can announce your verdict. It's 11:07 or thereabouts. If you want to take a lunch break, feel free. Just let our court officer know that you want to break for lunch. And remember not to discuss the case with anyone while you're at lunch. All right, with that, everyone please rise. You are free to leave. Thank you. Please be seated. So, Mr. Hess, Mr. Brand, Mr. Hoffman, if you all want to remain here, of course, in the courtroom, you're welcome to do that. If you want to go somewhere else, just be sure you leave your contact information with Ms. Gray so that she can get to you quickly. It's not uncommon that the jury will have questions during the course of their deliberations, and when they do, I need to reassemble quickly.
Yes, sir.
So thank you all. I'll be in adjournment until we hear from the jury. Thank you.
Thank you.